Welcome once again to the Labor Law Insider Podcast. This is your host, Tom Godar. I've been practicing law in the labor area north of 40 years. Hard for me to admit that, but all of this began back in May of 2021 when it was the premise of my colleagues and I at Husch Blackwell that elections have consequences. In the meantime, in those past 4 years, the Husch Blackwell family of labor lawyers has doubled. We've got incredible insider experience throughout our offices from coast to coast, and we've invited others from outside of Husch Blackwell to join us upon occasion as well. And so we are really excited to continue our Labor Law Insider podcast, and we promised you that it was a wild ride back in 2021. Well, folks, I just got off another call, read some more information on the internet, looked at a few more articles, and I promise you that we're in for another wild ride in the world of labor law. So buckle up and join us for the Labor Law Insider podcast. We're excited to have you join part 2 of this Labor Law Insider podcast with my colleague, Adam Dorr. He's been terrific at helping us examine what's really taking place at the ground level in the first 100 days of the Trump administration. We spent much of our first portion of this podcast talking about unfair labor practice filings. And if you listened, you know that they had a great blurb up right as General Counsel Abruzzo was being released from her role and right as Chairman Wilcox was being released from her role by President Trump. And then we saw an interesting, apparently, return to a more historic norm, even though it's quite a bit less than the number of ULPs that have been filed in 2024 over the same period. Adam offers a terrific analysis of some of these numbers and also offers insights into some of the whys. And in fact, that's where we're going to pick it up right now. I want to learn a little bit more about what the reasons for these trends are. And so let's pick up our discussion right there. Let me ask you, and this I know is speculation, but under the Abruzzo board, if you will, under the Wilcox board, the breadth of those activities which would constitute a ULP was expanded. And the remedies, if you were able to demonstrate an unfair labor practice, was expanded. Do you think that there are actions which are taking place which might have violated the act as interpreted by the Wilcox board, that because it's now more limited, or at least people anticipate that the board is not going to find those same activities improper, such as, derogatory comments, which might not have been the kind of thing that an employer would discipline for. And if the discipline occurred, somebody would say, that sounds like protected concerted activity being diminished. But maybe under a new board, they're going to say, no, that just sounds like disrespectful behavior, which you can discipline, that sort of thing. Do you think that we're seeing any of that, or is it just...
I think the issue you're talking about there comes in the form of how charge allegations are phrased, probably more so than whether a charge is filed at all or not. As you know, a charge often encompasses more than one allegation and can include dozens or hundreds if they're so inclined. And so I think where a party, an individual or a union or otherwise, is inclined to file a charge over perceived unlawful conduct, I think that charge still gets filed. But the way it's phrased, anytime the rule or the standard is changed, so too will the allegation, so that it alleges a viable claim. I think we'll see more allegations phrased in a different way. And maybe some of those specific allegations that had more of a chance under the prior administration, those allegations may not be brought. But I think that there's still going to be a similar number of charges brought.
So to summarize on the charges that you've looked at, we saw an interesting spike almost immediately, and you've read a number of other numbers. We never saw that kind of number repeated in the 30 or 40 or 75 workdays since, doubling up from the average to 70 or so, correct?
I haven't looked at the daily filings for every single day for the last 10 years, so I can't confirm that. It was curious, though, that it was a significant outlier just in the days leading up to and the days following. And I did look at the same time frame when President Biden was removing then General Counsel Robb. the days around that, and that happened on January 21st, literally the day after he was sworn in, President Biden was sworn in. So on those charges were 48 and then dropped to 25 and then picked up to 36 around General Counsel Rob's ouster, but no doubling of charges around that.
So you also looked at election filings, not elections, but just the filings for elections, which the process changed fairly significantly under, President Biden's board. It was made a shorter time to an election. It was changed the way in which employers had to be aware of filing elections. How is that, filing for elections changed, if at all? Maybe it's remained largely the same over these same 75 or 100 days since the Abruzzo firing and so forth.
Similar to the ULP's election filings, and I only looked at the RC and the RM elections. The RC elections.
Help us for, what does that mean, RCRM? That's a COLA, isn't it, RC?
The RC elections are elections filed by employees or unions seeking to represent employees in the first instance. RM election petitions are filed by management for the same purpose, to see whether their employees wish to be represented. I did not count RD election petitions, which are filed by employees seeking to decertify a union. So I was again curious to see whether Abruzzo and Wilcox's removal had a chilling effect on unions and employees finding the system to be helpful and, supportive of what they're trying to do, in this case, trying to seek representation. And in the days around that, again, just looking at January 28th, 2025, it did not have that chilling effect. I would have guessed that you would see a sharp drop in election filings in the day of removal, but it went from 7 up to 11 the day after they were both removed, and then to 8 and then 16 on January 29th. So there were definitely, or on January 30th, there were 16. So there was even an increase in election filings. Now, again, looking over the 72 days over a similar time last year, it's down 27%. But that's after a 47% increase, which came on the heels of the CMEX decision and everything else you were talking about.
Okay. Wow. We had talked a little bit about this, but I guess I hadn't heard that number before. That's a really big we talked about the ping-ponging of the Wilcox removal in the courts. This is a little bit of a ping-ponging thing, isn't it?
Yeah, and it's surprising looking at the same time period in 2023, so January to April 2023, there have been more RC and RM petitions filed this year than 2 years ago, despite the board lacking a quorum and the head GC and member Wilcox being removed. 496 compared to 463. And that's, I think, driven up by the CMEX decision, which, 2 years ago, there were only 6 RMs filed, whereas this year there's still been 42. So that alone just about makes up the difference. And we have almost identical RC filings in these 2 years.
Got it. I think that's interesting. And one of the things I'm taking away, and tell me if that makes any sense, I'm sort of taking away that on the ground, unions and employees are still willing to and expected to, and I think frankly ought to, protect their rights under federal law. And they're not hiding or going away because of changes from one administration to another. And likewise, unions that have assisted employees at a particular place of employment to seek an election, they're again not going to be intimidated about filing for that election. I know that's a really simple postulate, but what do you think? Is that partly what we're seeing? Are there more going on?
That's exactly what you've seen. I mean, the changing of the general counsel happens every administration, and the removal of the board member and the lack of a quorum really only means we're not getting decisions. So that's causing a little bit of a decisional backlog and handcuffing any change from decisions. But the statutory rights still exist, the filing procedures still exist, and as you know, 99% of cases of all kinds of litigation settle. So there's still reason to pursue claims, no matter who you are. And there's no indication that employees or unions have given up on the NLRA or the mechanics of enforcing it.
Well, it seems like so many of the times when we come towards the end of an interesting discussion, we say, so what's the practical implication for our friends and our listeners, our clients that tune into the Labor Law Insider? And oftentimes it doesn't terribly much challenge what we've heard before. That is, employees are still an important and essential and valued part of any enterprise. And by paying attention to their needs, by listening carefully to their concerns, by providing competitive wages and benefits and working conditions that make you an employer of choice rather than last choice, is going to be essential in avoiding claims of unfair labor practices or incenting employees to seek out unions to help them organize. And again, that sounds sort of every day we say that, but in some ways, just because there might be a more management-friendly board, it's not going to change that calculus, is it, Adam?
Absolutely not. This is interesting stuff from an academic standpoint, and it's important to practitioners to know how the procedures are working and what defenses they have and how to advise clients. But at the end of the day, labor law is all about how you're treating your employees. And employment law is the same way. If you treat your employees the right way, you don't have to worry about this stuff ever, no matter who's in charge. So, it's all about just making sure that you are not giving employees reasons to leave, reasons to sue, reasons to complain. And if you manage the workforce, none of this will actually matter. But I find it interesting. I hope you do too. And I think it does help practitioners shape and inform their practice, though our advice to the clients may not change dramatically.
There's an old R&B song covered by many. I think the original was Aretha Franklin. It goes RESPECT. Cannot tell you how many of my webinars and seminars for our clients have really heightened that as the really important element, that and fairness in all of our employment relations, whether it comes through the EEOC issues or whether it's related to LLRB issues. And that has not changed no matter who becomes in charge of the board, who's the chairman, all that sort of thing, RESPECT. Hey, and I really respect your thoughtfulness and contributing to the Labor Law Insider, Adam. As always, you bring a unique perspective and a thoughtful one, and I thank you so much for that.
It was a pleasure, and I appreciate it very much.
All righty. Well, thank you for listening to the Labor Law Insider. Thank you so much, Adam, for joining us, and we'll be talking to you soon. Take care.